Welcome, everyone. We're allowing people to join the Zoom right now. And so we'll get started once we see those numbers stabilize in a moment. For those just joining, our numbers are still climbing because of the Zoom function. And so we're just giving it a moment to allow the Zoom participants to finish joining the panel. Because we have a large number of people registered, it takes a little while for Zoom to fully populate. So my guess is we'll be able to start in a couple of minutes. I'm just still seeing the numbers continuously climbing. For those just joining, because it's taking a long time for a large number of people to join the Zoom, we're just giving it a moment. All right, I'm going to go ahead and get going. So welcome, everyone. I am Dean Hariosofsky of the Northwestern Pritzker School of Law, and would like to thank you for joining us today for this important discussion of the implications of the Dobbs v. Jackson Women Health Organization decision. I would like to thank Dean Charles Whitaker of the Medill School of Journalism, Media, Integrated Marketing, Communications, and Dean Eric Nielsen of the Feinberg School of Medicine for collaborating to have a much needed interdisciplinary dialogue about this decision's impacts. I'm grateful to the many people at all three schools who partnered to develop the event. I also apologize for my somewhat scratchy voice. I came down with COVID over the weekend and haven't quite recovered my voice fully. So as we will discuss today, the Dobbs opinion overruled Roe v. Wade and Planned Parenthood v. Casey, each of which recognized a constitutional right to receive an abortion. This decision has serious implications for the ability of pregnant people to access needed health care and for the medical system more broadly, which we will talk about in today's panel. Many people in this country, including me, have not experienced this country without the protections of Roe v. Wade. I was 7 months old when the Supreme Court issued its opinion in Roe v. Wade and turned 50 just before it was overruled. I grew up with its protections and also with harrowing stories about the experiences of pregnant women before those protections existed, and the deep inequalities that resulted from our patchwork of laws. Of course, Much has changed in those 5 decades, from medical technology to the way we communicate, which will influence the impact of Dobbs. But as our panelists will discuss, there will be deep inequalities that result from our patchwork of laws and their application that will affect pregnant people and so many others, and complexities as our 3 federal branches of government and the states interact on these issues. These issues are significant ones for our city and state, as Illinois maintains strong protections of the right to abortion, while nearby states have more restrictive laws. We have 5 expert panelists who will share their insights into the implications of the Dobbs decision. We'll begin with Professor Heidi Kitrosser of Northwestern Pritzker Law, who specializes in constitutional law with emphases on free speech, presidential power, and government secrecy. She's published widely on these topics and is a recipient of a Guggenheim Fellowship and the Palmer Civil Liberties Prize. Next, we will turn to Dr. Cassing Hammond, an associate professor at the Feinberg School of Medicine, who is an OBGYN who specializes in complex abortion and contraception care. He has been responsible for abortion education at Northwestern for more than 20 years and previously chaired the board of directors of the National Abortion Federation, the nation's largest professional association of abortion providers. Professor Paul Gowder of Northwestern Pritzker Law specializes in constitutional and legal theory, with particular attention to the role of race in our foundational constitutional ideas, among other things. His new book, The Rule of Law in the United States, an Unfinished Project of Black Liberation, was published this past December. Professor Doreen Weisenhaus has a joint appointment at Northwestern Pritzker Law and Medill School of Journalism, Media, and Integrated Marketing Communications. A former city editor of the New York Times, Doreen Weisenhaus specializes in media law and policy and global press freedom. And Professor Andrew Koppelman of Northwestern Pritzker Law teaches constitutional law. His new book out in October is Burning Down the House: How Libertarian Philosophy Was Corrupted by Delusion and Greed. We want to make this discussion as interactive as possible today, given the importance of these issues. After each panelist shares their insights on the implications of the Dobbs decision, we will turn to questions from the audience. Given the size of the audience, please send your questions to law-alumni@law.northwestern.edu. Ashley Wade has and will continue to post that email in the chat so that everyone has it who wants to send us questions. So with that, I will turn us over to our expert panelists. I'm beginning with Professor Heidi Kitrosser.
Great. Well, thank you so much, Dina Sofsky. And thank you, everyone, for attending and participating to talk about this extremely important topic and new development in the law. So I thought I would start things off with a little bit of legal background, as well as a little bit of legal commentary, particularly regarding the opinions methodology, as well as some comments about the implications for future cases, potentially, of the methodology that the court adopted. So one aspect of the leak, the initial leak of the Dobbs opinion, that I actually think was a positive outcome of that was the fact that it led to an extraordinary amount of examination and discussion of the court's reasoning in the Dobbs draft and then ultimately in the final opinion. I saw, just even in mainstream news programming, discussion of the court's reasoning, the court's methodology, in a way that I can't recall seeing for other opinions. And one aspect of the draft, and this is an aspect that's also in the final opinion, which is virtually very, very similar to the draft, is the methodology that the court said it has to utilize when it decides whether or not a liberty is a fundamental right under the Constitution, and therefore a right that has to be very, very closely guarded by the courts. And specifically what the Dobbs court said was they said, well, a right is only fundamental and thus deserving of special judicial protection if it's, quote, deeply rooted in our history and traditions. Now, just a little bit of background on that point. So first, I do think it's important to put that language into context and to recognize that the Dobbs court did not create that approach. In fact, the Dobbs court cited a 1997 decision, Washington versus Fluxburg, in which the court had cited the same language to say this is our approach to deciding whether or not rights were fundamental. That said, I think that the Dobbs court did use a bit of sleight of hand in suggesting that this is the approach the court always uses, that they always ask if a right is deeply rooted in history and tradition to determine if it's fundamental. In fact, the Supreme Court, as my students can tell you, as well as those who took other constitutional law courses can tell you, the court traditionally has tended to toggle back and forth, quite frankly, depending on who's in the majority, what the issue is, between asking is a right deeply rooted in tradition and history and taking a much looser approach. Nonetheless, the court here said, okay, it's only fundamental if it's deeply rooted in tradition and history. Although they looked further back than 1868 when the 14th Amendment was ratified, they said 1868 is the really important point. And they said, we don't see any evidence that, looking to laws in effect at the time, that abortion was considered to be an important, let alone fundamental right. So therefore it can't be today. Now, some quick commentary on that. So the court argued in Dobbs, as it has on the other occasions when it's adopted this kind of very cramped, historically bounded reading of a right, that it's necessary to take this approach because otherwise, the judiciary will just run hog wild and won't be restrained. I'll just note, and we can talk about this more in Q&A if folks want, there are really important counter arguments to that. Perhaps the most intuitive one is that this type of historical approach itself is arguably not very constraining, invites cherry picking. Also, there's an argument that normatively, this is a deeply unattractive approach because it sort of locks us into the limitations and prejudices of the time. And also that the court's selectivity in terms of what evidence counts also itself not only leads to sort of a selectivity in terms of just determining what history really demanded, but also locks in those prejudices and limits of the time. So for example, some folks in the wake of Dobbs have pointed out that there's an extensive abolitionist and pro-suffrage literature from around the time of the mid and late 19th century that was extremely focused on and supportive of reproductive freedom. But of course, that all gets ignored if you're only looking at official legislative pronouncements at a time when the vote and political power was largely restricted to white men. So that's a bit of commentary, a bit of background, and just real quickly, let me say something about the implications of this methodology. So one debate that has come up a lot in the wake of Dobbs is, well, what does this bode for other rights? What does this bode for cases like Griswold versus Connecticut that preceded Roe, upholding the right to contraception and treating that as a fundamental right? What about the right to same-sex intimacy recognized in Lawrence v. Texas, to same-sex marriage recognized in the Obergefell case just a few years ago? What about the right to interracial marriage, et cetera? Now, as many of you have probably heard, Justice Alito was very careful to say over and over, this case has nothing to do with those other rights. But the reason I think advocates and commentators are right to say, well, actually, if you take what the court says seriously, it does call into question those other rights, is that the court's methodology that I just talked about arguably wouldn't accommodate those other rights. Now, the court gave a few distinctions, and the main one it relied on is that Justice Alito repeatedly came back to the idea that only abortion involves what he called the destruction of fetal life. I would argue that's not very analytically sound, because that speaks to the interest that the state might claim on the other side of the right. It doesn't speak to how strong the right itself is. So that's just a little bit of an explainer and some commentary about the legal methodology. And I really look forward to hearing from the other panelists and the audience.
Thank you, Professor Katroser, for sharing these insights. We're next going to turn to Dr. Cassing-Hammond for his perspective on the implications of the decision.
Well, my perspective may be a little bit different than the other panelists because I'm the sole physician on the panel, not an attorney. And I think the perspective that I offer is that abortion is first and foremost a health issue. And the implications of Dobbs just could not be more far-reaching or foreboding to my patients, to fellow healthcare providers, and also to the people that I train. I want to remind everybody at the outset of our conversation today that abortion is both safe and it is common. The risk of death from childbirth in the United States is 14-fold greater than the risk of death from any abortion procedure. Indeed, the risk of dying from a first trimester suction curettage abortion is 1 in 1 million. That is less than the risk of death from a single shot of penicillin, and certainly less than the risk of death from the car ride into the clinic to have a pregnancy termination. Abortion is also incredibly common. Roughly 1 in 4 American women will have had at least one abortion by the time they hit age 45. It's the second most common gynecologic procedure, second only to cesarean section in the United States. Now, to put that at a more granular Illinois kind of level, there are about 40,000 abortions occurring in the state of Illinois every year. Roughly 20,000 of those occur within a 20-mile radius of our downtown medical center. We expect that that number of abortions per year could double as a result of Dobbs. That is an astounding thing to consider. Are we ready for that number to double? No, we aren't. We're not ready at Northwestern. We're not really ready in Illinois. And I know that the providers are not really ready in the restrictive states. Restricting a procedure that's this common is going to impact nearly everybody who provides healthcare to people who can become pregnant. So I was asked what I thought from my vantage point the impact of Dobbs is going to be. Well, it's going to impact several different groups. First of all, and most obviously, it's going to impact individual patients. It's going to impact women who seek ordinary abortion. We don't like the term elective, so I will use the term ordinary. And it's also going to impact those women who seek abortion because of fetal anomalies, because of health-threatening complications of pregnancy, and because of maternal health issues that make pregnancy more dangerous. It's also going to affect how providers in restrictive states manage miscarriage, ectopic pregnancies, and might influence the type of contraception that they can offer. Second, Dobbs is going to impact women's healthcare providers. Abortion providers in Illinois are already confronting a surge of patients. My friends who work at community clinics, both in Chicago and also in downstate, are telling me that the number of phone calls to their clinics has tripled in the short time since the Dobbs decision. Meanwhile, women's healthcare providers in restrictive states will soon have to contend with complications of self-induced abortion that we have not seen in the United States in generations. And all providers are going to have to contend with laws that criminalize standard of care medical practice, including vigilante laws that some fear could be used against physicians in any state. Dobbs is going to impact other healthcare providers as well. Emergency departments are probably going to see far more women who are experiencing abortion complications, both complications of legal abortion and also illegal abortion. Labor and deliveries are going to see more induction terminations. And finally, Dobbs is going to affect the people that we train. If 26 states ban abortion, who trains their student doctors in abortion and abortion complications? How do we decide in the less restrictive states who most deserves training? And finally, how does lack of abortion training impact non-abortion training? Will the inability to teach abortion inherently weaken residency programs in many of the restrictive states, some of which are powerhouse OBGYN programs, including the largest program in the United States is in a restrictive state? Other panelists today are going to address Dobbs and abortion as a legal and a human rights issue. But in closing, as the sole provider on the panel, I just wanted to note that assuring equitable access to contraception, to abortion, to other women's health services is really part of a pledge that my colleagues and I all made when we became women's health care providers. We consider it a virtue. We consider it a responsibility. It's something that we absolutely cherish. And I would note, it is something that has always distinguished Northwestern in the 27 years that I've been here. Unfortunately, the Dobbs decision threatens our ability to fulfill our pledge to our patients, to our colleagues, and also to the people whom we train.
Thank you, Dr. Hammond. We're now going to turn to Professor Gowder. Before we do, I just wanted to remind people, as Ashley Wade's posting, that you can send your questions to the panelists, which we will address as many as we can of as soon as these introductory remarks are done, to law-alumni@law.northwestern.edu. Professor Gowder.
Thank you so much. So I'm going to try to be fairly brief and focus on particularly the racial dimension of this case. And so the court actually both minimizes as well as, really sort of turns in a fairly sinister direction the racial implications of the right to choose. Footnote 41 of the Dobbs opinion mentions the well-recognized fact that disproportionately Black women have chosen to terminate pregnancies in recent years. The court mentions it in context of the fairly, how shall I put this, pernicious implication that advocates for the right to choose have some kind of eugenic agenda, which I think obviously is false, but also fails to recognize that there are reasons why Black women disproportionately have chosen abortion. And those reasons are rooted in our overarching system, quite frankly, of white supremacy, right? So, we know there's plenty of evidence that the consequences of racism, everything from environmental racism, see, for example, Flint, Michigan, to the stresses of discrimination, subject Black people to worse health outcomes. We have plenty of evidence that Black people get worse medical care, that Black women are perceived as more resistant to pain than white women are. We also have, of course, plenty of evidence, thanks to systems like segregation and mass incarceration, that the burdens of child rearing on Black women on the whole are typically substantially higher. And so the exacerbation of existing racial inequalities by this ban is something that I think by bans in the states that will implement them, is something that seriously I think we cannot ignore. A somewhat deeper point though, another fact that the court utterly fails to acknowledge in the context of its claim that abortion rights are not historically rooted, as Heidi mentioned very briefly, is that forced birth was a key element in the economics of slavery. And I apologize if I'm stealing any of Andy's thunder relative to the 13th Amendment, but every person who studied the history of slavery at anything more than the absolute shallowest level realizes that a key portion of the economic value of an enslaved woman was the fact that that woman could be raped, and then the children of that rape would be the property of the master, frequently the rapist. It is also well known that in response to this, a number of enslaved women procured ways to terminate their pregnancies against the will of the masters. And so for the court to say, in purporting to interpret the 14th Amendment, enacted to regularize the legal status of freed slaves, that a right to abortion was not historically rooted, without even discussing the relationship between forced birth and enslavement, is, in my view, unconscionable. Thank you.
Thank you, Professor Gowder. Appreciate your remarks and highlighting these important inequalities. We'll next turn to Professor Weisenhaus.
Great. Thank you, Dean, for that. So I'm here to discuss the implications of Dobbs v. Jackson on journalism. And you really could not get a bigger story that has attracted more of the American media and journalists than the overturning of Roe v. Wade. And for some of the very reasons of the stories that are mentioned for the previous panelists. So the impact on healthcare, the impact on the racial implications, the legal theories, and so forth. And it's been an incredible struggle, and it will continue to be this amazingly challenging story, not just in the immediate aftermath. What is the decision? What are some of the protests, both celebratory or decrying the decision, but really what is the direct impact? So there's an immediate pivot on the part of journalism to try to sort out, okay, what's happening in tracking the state laws, what's happening in the battles in the state houses, but also this personal impact, the personal legal ramifications for the individual women and the providers, as Massine mentioned, what is the implication for them? Will there be travel for abortions? What pills are available for abortion? What impact on contraceptives, IVF? What will happen to the embryos and how they be managed? Personal data issues, such as women who are using fertility apps. Will that information be shared by those apps with law enforcement? Because the big change here is the possible criminalization. So it's an incredible challenge, and the media is starting to follow that, but they also have the responsibility and looking out for the bigger stories, the bigger rippling stories. So the New York Times yesterday had a couple of stories, one looking at the economic ramifications for those states that are banning abortions, or what are young people going to do who are living in Texas, who are living in some of those states? Will they be moving out? Will they go other places for their healthcare needs? But then there's even these bizarre stories that they're kind of tracking, because it really says something larger about some of the issues. So in Texas, there was this very pregnant woman who was given a traffic ticket for driving in the HOV lane. And she says, no, this is not applicable to me. I have a second person here, and pointed to her unborn child. And so where these things go and where they fly, it's difficult to say. But I do want to take just a moment to talk about a specific subset of journalists, and those are the ones who are the veteran legal reporters covering the Supreme Court. And I spoke with a number of them after the decision. And 201, they felt and knew that this was something very monumentous, and not just from the historical aspect of this decision, which wasn't just from June 24th when the decision came out, wasn't from the May 2nd leak, but going back to December during the oral arguments, and saw where those questions were going, that something really special was happening with this term. And how do they address covering some of these issues? Some of the women I spoke to, women journalists, said, how do they separate their personal feelings, and the personal impact this has, yet knowing that they need to have objectivity in covering this, and their mothers, and they have daughters, they have granddaughters, and so on. And this has opened a chapter for media organizations to now reissue warnings to their reporters to not post their personal opinion on social media because you don't want to give the impression of a lack of objectivity. But the special Supreme Court reporters do know that there's something going on here, and they're going to be covering it with that frame of mind moving forward. Some of them have dubbed this very activist conservative court as the YOLO court. You only live once. They're going to do as much as they can, as fast as they can over this very short period of time. So there has been this kind of change perception and how they're covering this. I'm not going to talk about the divide between the conservative media and liberal or mainstream media. I think we know where a lot of that has gone in terms of the differences, except to say that in the immediate aftermath of the decision, the coverage was fairly similar. It was a factual discussion of what the decision was and what the case said and so on, but the divergence obviously went in the expected ways. If anyone has any questions about how that went, I'll tell you, except that I will share that Breitbart, the headline on this was prayers answered, life wins. And so that kind of gives you a sense of where their coverage was. But I also don't want to exclude the foreign press coverage, of which it's been huge. It has dominated front pages around the world, not just from the decision, but going back to May 2nd, as a way of looking at what happens in America has an impact elsewhere in the world. Abortion is not just a US issue. It is in play around the world, and what happens in the US can have some impact. Some countries in Central and South America have opened up. So Mexico, Argentina, and Colombia, they have opened up. But in much of the world, Eastern Europe, Africa, Asia, the Middle East, there is so many more restrictions, and more are anticipated to happen in this aftermath. Countries like France have already introduced post this decision for bills to try to enshrine a woman's right to abortion in their constitution, trying to learn from what has happened here in the US. And so journalists, I think, going forward are going to be looking and being creative, but there is some issue of dealing with the resources. There's so many other stories to cover. This year alone, there have been over 320 mass shootings. And so their resources are going to Uvalde, they're going to Buffalo, they're going to Highland Park. They're covering economic issues, inflation, what's happening with the midterm elections, the January 6th hearings like today. So there is a challenge for the media. I think there is very strong interest in pursuing forward, but I think that they'll need assistance from all the different sectors to move forward. This story is not going to go away.
Thank you very much, Professor Weisenhaus. And we will now turn to Professor Koppelman to provide the final panelist perspective. And after that, we will turn to Q&A. We've been getting a lot of questions in, and we're going to try to get through as many of them as possible following Professor Koppelman's remarks.
All right, so I'm going to talk a little bit about the constitutional issue, and then I'm going to say something about the way forward. So I have been making a constitutional argument, which for some decades, which the court ignored, that abortion is protected by the 13th Amendment, which abolishes involuntary servitude. As Paul said, compulsory motherhood, the requirement to bear children against one's will, was constitutive of slavery, was part of what it meant to be a slave for a large part of the slave population. One thing I've noticed since Dobbs is that I've been hearing more interest in this argument in the past, and there have been creepy new parallels. The phrase Underground Railroad is already a common label for the resistance. Some legislators are considering restrictions on free speech in order to prevent the subjected population from learning its options. There have been considered restrictions on interstate travel. A few states already authorize private bounty hunters to help with the new enterprise of trying to prevent women from escaping forced pregnancy. There have been efforts to punish would-be rescuers. And I think that these parallels ought to give you pause, even if you are part of the large anti-abortion faction of American politics. The datum that we have from other countries that I think is most pertinent here is that worldwide data shows that the rate of abortion is actually not that different in countries that ban abortion from those that permit it. Women who want to end their pregnancies usually find a way to do it. The Texas law that banned the procedure after 6 weeks and the Supreme Court allowed to stand. Now that law comes into effect at a time when many women don't even know they're pregnant. We know from studies the actual rate of abortion in Texas only declined by about 10%, and we can expect a similarly small change all over the United States. On the other hand, we do know that fear of criminal prosecution has endangered women who want to have children. Because if you say you are going to criminally prosecute doctors who end pregnancies where the life of the mother is not in danger, that leads, it's already leading obstetricians in Texas to delay intervening until the woman's condition deteriorates to the point where they can prove that her life is in danger. In Poland, at least 3 women died under a similar statute because their doctors waited too long. There are already hospitals in Texas that are afraid to terminate ectopic pregnancies where the embryo has no chance of being born alive. There is one hospital in Texas which, when it teaches residents how to treat miscarriages, the emptying of the uterus is something they used to learn via abortion. Now, the one hospital teaches them using a watermelon in lieu of a uterus. And all this helps to explain why abortion bans are associated with higher death rates among pregnant women. There is a better way. Over 70% of women who seek abortions cite financial pressures as a reason for their decision. About a quarter of them say that that's the primary reason. Most of the women who abort are already mothers. Most of them are afraid they wouldn't be able to provide adequate support for the children they already have. And they're right to worry, given the data about what happens when women are denied abortions. So pro-lifers ought to be demanding a restoration of the child tax credit, which pulled millions of children out of poverty. And there's evidence from several countries that better financial support for families reduces the abortion rate. Today's American political landscape offers, I think, a stark choice. You can have better financial support for people with children, which one political party will give you, or you can have laws criminalizing abortions, which the other political party will give you. But the regime that we are now looking at, which brutalizes and sometimes kills pregnant women while ignoring the most promising opportunities to prevent abortions, ought to discuss both sides. We ought to be allies on the question of what to do. Thanks.
Thank you very much, Professor Koppelman. Well, I really just want to thank, before I turn to the questions, each of the panelists for providing their insights. It really reinforces the importance of having a cross-disciplinary conversation about these issues, because an important decision like this one is not just about legal questions, but also about health questions and about journalism questions and how we communicate. And so it was so helpful to hear the different perspectives of the panelists. At this point, I'm going to turn to audience questions, and we have a lot of different kinds of questions, and I'm going to do my best to kind of group them and give them to each of our panelists to comment on. The first thing is we have a couple of medically oriented questions that I'm going to send to Dr. Hammond. In particular, we have questions about how the decision will impact infertility medicine, in particular IVF and PGT testing, and also how the ruling will impact miscarriage care and ectopic pregnancies. So I thought I would turn those questions to Dr. Hammond.
Sure. I think of the three, probably the most important to consider is miscarriage management. It allows you to kind of get your head around some of the collateral effects that some of the restrictive laws that are going into effect in different states will damage the practice of medical care that many in the public don't think of as strictly being abortion. I watched as some of the questions about miscarriage came through, and some people were asking, well, how does this affect management if an embryo or a pregnancy has already died? And obviously, if the pregnancy has already died, if it is no longer viable in that sense, then these laws will not have impact. But miscarriage is not that straightforward. There are a range of miscarriages that we can diagnose in both the first and second trimester. And if you imagine some of these clinical scenarios and the position that it's going to put doctors and patients, you can get an idea of why many of us think these laws are potentially quite cruel. Consider patients, for example, who have preterm premature rupture of membranes. We commonly see people who are in the second trimester of pregnancy where the bag of waters has ruptured. The pregnancy is still alive, but the prognosis for the pregnancy is dim, it's dismal. We know a large percentage of these patients, because they've lost the protection of the bag of waters from infection, will go on to get infected, and some can become septic and some can die. Many people are already familiar with the famous case of this from Ireland, where a dentist who was pregnant experienced rupture of membranes in the second trimester. Her doctors, because of legal issues, would not intervene to evacuate the uterus, and she ultimately did become septic and die. And it was very important in the Irish movement to legalize or to pass less restrictive abortion laws. But we see this all the time. There's already been a case in Texas where a patient had to leave Texas and go to New Mexico because no doctor was willing to intervene until the patient really had her life threatened, even though we knew the prognosis for the pregnancy is dismal, and even though patients who have PPROM usually view themselves as having a miscarriage because the pregnancy is in the process of being lost. This isn't the only scenario of miscarriage that we see. We see people on my service all the time who have significantly advanced cervical dilation from insufficient cervices. Let's say they're 16 or 18 weeks, maybe their cervix is already 4 to 5 centimeters dilated. It's highly improbable that that pregnancy will go forward. They may risk periviable birth if it goes forward long enough, but in the patient's mind, again, they're losing the pregnancy, even though, yes, there's still a heartbeat. What about the first trimester? We see people all the time, since 15% of pregnancies miscarry, who are bleeding significantly in the first trimester, maybe not enough to jeopardize their life, but enough that their health is at risk. And we would typically intervene and evacuate the uterus. We see people with inevitable abortions, which is just where the cervix has opened up and the patient hasn't lost the pregnancy yet, but we know that it can't go forward. All of these scenarios are situations where in the past we would have a conversation with a patient and say, the prognosis is bad. What's best for your health? Let's not let it get to the point where your health is going to be jeopardized. But in restrictive states, the laws now are going to make it a felony for physicians to do anything but wait and let patients get sick. You mentioned other scenarios. I don't want to use up everybody's time, but yes, ectopic and also IVF. IVF often destroys embryos in the process of creating viable pregnancies, let alone the issue of what to do with remaining embryos after somebody has finished IVF, if those embryos are considered persons. And ectopic pregnancies are complicated because, as was already said by a panelist, we typically diagnose ectopics before they get to the point where they're going to rupture and kill somebody. They can be anywhere in the body, they can be devastating. And we now find them before they become as much of a problem by following serial blood tests and ultrasounds. But what to do if that embryo, that fertilized egg, is now considered a person and you can't evacuate it until the patient is at death's door? I've already heard of cases in a restrictive state in which doctors are waiting for the patient to have a hemoperitoneum before they will intervene. They are waiting for the patient not just to be diagnosed with an ectopic, but to have blood in her belly and to becoming unstable before they will intervene. That's exactly what we don't want. That's what we see in the developing world. That should never be happening in the United States.
Thank you, Dr. Hammond. We've also had a number of different kinds of questions about, putting this in broader context. And I guess the next one I'd like to put to the panel is reproductive governance is a crucial issue everywhere, and abortion is illegal or limited in so many countries. How might panelists place this decision in transnational perspective, not just in terms of individual countries, but in terms of the fallout of the US's decision elsewhere? Would anybody like to take this question?
I'll just take a quick stab at one small aspect of it. The transnational context definitely falls outside of my area of expertise, but one aspect that I can speak to is I know that a sort of a talking point, I think, since the Dobbs decision on the part of mostly anti-abortion advocates, but I think also just some folks generally trying to say, don't worry, Dobbs isn't really that big of a deal, is that certain European countries have, in particular, France comes up a lot, has laws more restrictive than many of the US abortion laws. And that, my understanding just from having read a little bit about this is that is really a false notion, partly because it doesn't take into account the many exceptions in the French laws, but also because it fundamentally fails to take into account the huge differences between the French healthcare system and the US healthcare system, among other things, that abortions are fully paid for by the government in France, that it's much easier to access care of all kinds, including abortion care, to do so in a timely way, et cetera. So that's just because I think that's such a sort of common misstatement making the rounds these days. That's one aspect of it I can speak to a bit.
Thank you very much, Professor Kitrosser. And it looks like Professor Weisenhouse has something to add.
Yeah, and just to add to Heidi's point about France, and they do recognize that there are aspects of their laws that maybe are antiquated, there maybe are not updated and so on. And clearly, the right to abortion is not in the Constitution. So they're trying to take a cue from what the US experience was and say, okay, we're going to enshrine this. And I think there will be movement to take care of that. So what the law says and what the actual practices can be two different things. So in Israel, for example, there are a lot of restrictions on getting abortions. But after the decision came out in Dobbs, they said, okay, we're going to address some of them. And so even though in some ways they're more restrictive, but they do have universal health care, there is more access. So a woman wanting to get an abortion actually had to appear before a committee of 2 doctors and 1 other health care professional to give a reason as to why she wanted that abortion. And they had very specific rules. You can have one if you're under this age or if you're over this age. And now they're going to be relaxing some of that in light of this decision. So it's really kind of a false comparison, as you mentioned, but certainly there will be an impact going forward.
Thank you very much, Professor Weisenhouse. We've also gotten a large cluster of different kinds of questions about the criminal law implications, and particularly in the context of kind of interstate travel. So there's obviously the reference in Kavanaugh's concurrence that gets brought up, but also sort of these questions of, if somebody crosses between states which have different laws, sort of the implications for what can occur, with them. And I've also been hearing, I didn't see it in the Q&A, but related to this is a series of questions about non-prosecutorial discretion and what's happening within states where there are sort of differences of opinion about sort of enforcement too. So I see Professor Koppelman on this one and Professor Gowder.
So on the prosecutorial discretion, I mean, some prosecutors have said that they will not prosecute abortions. It is not safe to rely for anyone to rely on that because prosecutors change, and they change during the time when the statute of limitations is not expired. And so it's possible to criminally prosecute despite the representations of a prosecutor. So no doctor or patient can safely rely on that. Justice Kavanaugh did say in his concurring opinion that there is a right to travel. The right to travel, of course, does not protect against a state law that makes it a crime to abet somebody traveling out of state to get an abortion when the abettors' behavior is in state. If I am a company that pays for my employee to travel out of state, I have done that within the borders of my state. And then there is the I thought absolutely astonishing decision of the Supreme Court to leave undisturbed the Texas statute that creates liability for anyone who abets an abortion. What's extraordinary about that statute is, you've got jurisdiction to file suit if you like 1,000 miles away from the home of the person you are suing. And if they don't show up, you'll get a default judgment against them, which has a powerful deterrent effect. Some right to lifers have celebrated this statute, but this can be deployed against any activity whatsoever, including activities that are obviously protected by a constitutional right. If a state passes a statute saying that if someone celebrates a Catholic mass in their state, someone else in the state can file suit against them for a large bounty, obviously unconstitutional statute, but if you make them travel 1,000 miles to answer that suit on pain of a default judgment if they don't, that will have a chilling effect on the Catholic religion, even though the statute is unconstitutional. The aspect of the court's behavior that I think goes even beyond their awful decision in Dobbs is the decision to allow that to stand, which basically allows the states to nullify any constitutional right they like.
Thank you, Professor Koppelman. Professor Gowder.
Yeah, so a couple of additional notes on this. So one, I want to go back to something that Andy said in comparing the situation that we're now seeing around abortion to the situation at the time of slavery, right? I mean, to my mind, we're going to inevitably have fairly serious interstate conflicts, conflicts that we saw during the time of slavery, because this is essentially this is what happens when different states with right to travel between them have different conceptions of what people's fundamental rights are. As we're going to see, for example, questions over cross-state enforcement of these kinds of judgments. And it's going to be, I think, very hard to successfully operate the principle of comity between states, so long as different states have different conceptions of these fundamental rights. The court in Planned Parenthood versus Casey, I think, the court in Dobbs sort of poo-pooed a lot of the discussion in Casey of stare decisis and reliance and the kind of settlement function of constitutional doctrine. But I think the impending interstate conflicts are going to show us that, in fact, the court in Casey, or the plurality in Casey, was right to focus on those features of settled constitutional doctrine. The other thing that I want to note, and this is by way of being a little bit more subversive, one thing that abortion advocates are talking about in the context of the risk of criminal prosecutions is a very old legal principle that our founding fathers and so forth particularly liked. That very old legal principle is jury nullification. Juries have the power as long as they don't admit that they know that they have the power when they're being selected. American juries, because then you'll just get thrown off the jury. American juries have the power to say, no, I will not convict, regardless of whether or not the prosecutor has proven the elements of some crime. This is a power that can be used perniciously. It was used by juries during the Jim Crow era to protect lynchers, but it is also a power that can be used to protect the people who are being charged with crimes that the jury or members of the jury sufficient to prevent a conviction feel deeply unjust. And I'll sort of just drop that factoid out there in case it's relevant to anybody watching.
I've got less confidence than in that for the same reason that the danger that if a doctor fears that providing appropriate treatment to his hemorrhaging patient will land him in jail, he's not going to get much comfort from the fact that, well, maybe the jury will nullify.
Oh, no, we shouldn't have any comfort from it. But if anybody happens to find themselves on a jury, it's something they should know.
Thanks. It's always great to see the dialogue between panelists. I'm going to try to get us through two more sets of questions. I may let us go slightly over since due to the Zoom joining, we started 5 minutes late. So the next set of questions I have are related to religion. I know religion's already come up in some of these answers, but in particular, I had two sets of questions. One about how the court's decision should be viewed in the context of separation of church and state. And in particular, that religions view pregnancy and recognition of fetal life differently. And so there are a number, someone specifically references, for example, differences between Judaism and Christianity on these issues. And so I open it up to the panelists for the sort of these questions of how these decisions interact around constitutional protections around religion. Professor Gowder.
So there's a landmark case, right? Actually, a Scalia opinion of all people, Employment Division versus Smith, which says that essentially religious believers are not entitled under the First Amendment to exemptions from generally applicable laws. Now, but under the federal law and a variety of states that have passed similar statutes, that's changed because of statutes known as the Religious Freedom Restoration Acts. But as a general constitutional principle, that would protect state restrictive laws, except for one inconvenient fact. That inconvenient fact is that there are 5 justices on the Supreme Court who've said that Employment Division versus Smith should be overturned at some point, or who seem to strongly think that it should be overturned. I mean, my guess, and Andy's again, much more expert on questions of freedom of religion than I am, but my guess is that Employment Division versus Smith's days are numbered. And when that becomes the case, if we take seriously the claims about religious freedom that a number of people on the current court have endorsed with respect to things like churches holding services and so forth under COVID restrictions, if we suppose that those are in good faith, then we would expect that believers who believe that their faith requires them to privilege the health and well-being of the mother over that of the fetus have a entirely plausible claim for an exemption from abortion restrictive laws.
So I think the question really has two aspects, establishment and free exercise. So the argument is sometimes made that it's an establishment of religion because they to prohibit abortion, because the belief that a fetus is our rights-bearing entity is our religious view. I actually don't subscribe to that. There are all kinds of things that people value for reasons that they can't explain that happen to coincide with their religious views, but you can legislate on the basis of them. I think the Endangered Species Act reflects an inchoate sense of the sacred that's held on the part of many people, and I don't think the Endangered Species Act violates the Establishment Clause. Free exercise is harder because we know that at least within some forms of Judaism, abortion is under some circumstances required. The court is not committed to overruling the Smith decision, which Paul just described, but they certainly have come up with lots of elaborate ways of getting around it so that it is effectively overruled in many contexts. The box this places the court in doctrinally is that if one thinks that religion is being discriminated against, if strict scrutiny is triggered, which I think could easily be the case in at least some abortion cases, then the court would have to decide the very thing that it has just said that it doesn't want to decide, which is whether the state's interest in protecting the fetus is a person, which takes it exactly into the metaphysical questions that it wants to stay away from. I have a guess as to how the judges will answer that, but I cannot figure out how they would write the opinion without expressing in a view about the very thing that, at least in this opinion, they were so determined not to express a view about.
Thank you. Oh, Professor Kitrosser.
Sorry, just to jump in real quickly, just kind of dovetailing off of the last thing that Professor Koppelman said. You know, in my opening remarks, I mentioned in passing that Justice Alito, in the opinion for the court, and Dobbs, you know, repeatedly says, "Oh, don't worry, abortion is totally different. It's nothing. Roe and Casey have nothing to do with the, you know, other cases upholding fundamental rights." Such as contraception, et cetera. And he repeatedly says several times, it's because abortion is unique in that it involves the destruction of fetal life. As I've mentioned, analytically, that's kind of incoherent because that might factor in terms of the state's interest on the other side of the balance. Doesn't explain why the right itself, the woman's right, isn't fundamental. But if the court really felt backed into a corner. And I don't know that it will. I think it may be able to sort of duck the question, perhaps just by not taking certiorari on cases involving Judaism or other cases that raise the scenario that Professor Gowder mentioned. But if it was sort of backed into a corner and had to address that issue, I think that Alito's repeated you know, reference to the destruction of fetal life and the use of that language suggests that the court might just go ahead and say there's a compelling state interest if it has to apply strict scrutiny in protecting fetal life. Without actually saying the words, as Professor Koppelman suggested, we decide it's a person. You know, even though these two things might seem in tension to say we're not deciding if it's a person, but we're deciding there's a compelling interest, I could see the court taking that, trying to thread the needle in that way and saying, oh, we're not going to decide this difficult philosophical, theological, medical question of whether it's a person, but we are going to say that the state, when the state takes the view that it is, that interest is so compelling that it can even overcome a faith-based belief in the need to provide abortion.
Thank you, Professor Kitrosser. So I think I rather than try, we've had the last set of questions I was going to get to were, but a number of questions about kind of judicial legitimacy, with somebody quoting Professor Belinda Greenhouse's comment, they did it because they could, but a variety of different kinds of questions about that. And of course, our minnow debate just a few months ago focused on questions of court packing. So I wanted to raise that question, but what I'd like to do, since we're over time, even with my giving us a few extra minutes, is to just give each panelist a chance to go around, and you can hit this final set of questions or not in your comments, but maybe just a 30 seconds of just some concluding thoughts to share. And so why don't I do that in Professor Weisenhaus.
Yeah, so just quickly, I think what you will see is more coverage of this exact point, where it's not just going to be covering what the decisions are, but what is going to be happening with them. You'll see more aggressive coverage of the shadow docket and the kinds of cases that they're now deciding. There's been a lot more aggressive look at the kinds of other cases that they're bringing. In the past, they looked at conflict cases before they brought them in. The abortion case did not have that. So I think you'll see much more media attention and commentary attention on this very issue of how this court is acting in a more aggressive way, and really kind of irrespective of public opinion and media coverage, which had been more of a factor under Chief Justice Roberts when he had a little bit more control over the court, and he was very conscious of whether or not the court was tracking more of what public opinion was in the country at large.
Thank you, Professor Weisenhaus. Professor Koppelman, any closing comments?
So I have to say, when I was not enthusiastic about any of President Trump's 3 appointments, but I did not openly oppose them because I thought, these are smart people, and I expected them to exercise judgment, though not the judgment that I'd agree with in every case. But I think that we're in a whole different world. They have crippled the ability of the federal government to deal with disease and to deal with environmental catastrophe. And I think this is a court that is just completely lost to judgment. They've been completely captured by a libertarian narrative that is indefensible. So I'm now willing to embrace ideas like court packing that I resisted a couple of years ago because I did not expect them to be just as crazy as they've turned out to be. I'm frankly shocked by the work product of the last year.
I thought I saw you unmuting, Professor Kitrosser.
You did. So I'll just sort of end by coming back to something I mentioned at the beginning, which is that in the wake of Dobbs, particularly the initial draft leak, I saw a remarkable amount of substantive discussion, even in mainstream media, about the nature of the opinion, the methodology. That is one thing I'm heartened by in the public response and coverage of the Dobbs decision. And in that regard, and this ties into Professor Koppelman's point about the court at present as well, it makes me think back to a speech that Justice Amy Coney Barrett gave, several months ago, maybe a year ago, at the McConnell Center in Kentucky, standing in front of Mitch McConnell. She gave a speech about how unfair it is and wrongheaded and ignorant it is for anyone to say that the court is politicized. And in particular, among the points she made was that, this idea that the court's political is based on a misunderstanding because people just look at the results and they don't understand the reasoning. And if there's one heartening thing to come out of this term is that we are increasingly seeing people picking apart the reasoning. And I think in doing that, much of the criticism we hear along the lines of Professor Koppelman's criticism, with which I completely agree, so much of it is based on that substantive dissection. And so much of the kind of rides and support for measures many of us would have thought too extreme in the past, like court packing, comes from that. So we'll see what happens going forward.
All right, Professor Gowder.
Thank you. So one of the things that political scientists often say about constitutional law is that a key one of its functions is to lower the stakes of politics. It is lower the stakes of politics because if people can feel relatively secure that their basic rights are going to be protected, then they don't have to fear serious oppression in the political realm. And as a result, there's less polarization, less risk of violent changes of power, so on and so forth. That function of constitutional law only holds if you have a high court that is willing and able to maintain a stable, well-established set of rights, even if they're rights that not everybody agrees on. And I think there's, strong reason to believe that this court does not have that character. And for that reason, the American people need to restore that character in their court by using the political mechanisms to sanction it.
Thank you, Professor Gowder. And last but certainly not least, Dr. Hammond.
Well, I think I'd end on a slightly different note. Certainly within the medical community after Dobbs, there has been anger and there is fear for the very reasons we have talked about with vigilante laws, fears of being prosecuted for felonies, fears that you won't be able to provide the kind of care that all of us want to provide patients. But let's think about something that is really amazing and good, since it would be nice to have something positive to end on. And that is the response of a lot of providers, their resolve not to give up and to take action and to do something that is positive on behalf of patients. Back in January, as many of us here in Illinois began to anticipate the Dobbs decision after it was argued in the Supreme Court, we formed a loose-knit organization that we've nicknamed the Illinois Coalition of Abortion Providers, which abbreviates nicely ICAP. And it started as a very small group having Zoom meetings to say, what can we do to get ready? And grew, and now includes pretty much every state provider, large and small, representatives from Missouri, Tennessee, Indiana, elsewhere. ACLU is involved. We have an attorney ethicist advising us, Illinois Department of Public Health. So many others now join the call so that we can get ready. And we're getting ready. We've watched as community clinics are expanding, both upstate and downstate, to get ready for the surge of patients. We're preparing from a security standpoint. If we start seeing more of the protesters who traditionally have been in what will now be restrictive states, we're preparing with patient navigators, both to help patients get to the community clinics, but more importantly, patient navigators who will help sick patients who can't be taken care of in the community find their way to hospitals and between hospitals. And in fact, we are working with the many important abortion funds. People asked where they might be able to donate. Organizations that help patients who need food, travel, lodging, all the things that aren't directly related to payment for the service, but are necessary if people are going to be served. We've also finally had a torrent of requests and pleas to help us. People in the community who are trained to do these procedures, and maybe they haven't done abortions for a few years or so, but they're saying, how can I help? How can I help the uninsured women? I'll do it for free. Tell me where I can go. There is resolve like I've never seen. And I would end by saying what this demonstrates is we had a question about people having abortions for religious reasons. But let's also remember that people who provide abortions do so as a matter of conscience themselves, whether it is religious or not. People do abortions and help patients because they have conscience and because they are moral people with a moral compass. And we're seeing that in action right now in Illinois and in so many other parts of the country.
Thank you, Dr. Hammond. So I hope that everyone will please join me in thanking our panelists for sharing their insights on this very important topic. And I want to thank, again, everybody who helped put the event together, and also all of you for joining us for this dialogue and for your questions that allowed us to be in dialogue. So thank you, everyone.